Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I'm your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court. And we are here with what might be the last step of the Ray Andiachero versus Karen Yaks saga. For those of you who have been following this, Karen Yaks, otherwise known as the Critical K or Critical K, is and was a YouTuber, true crimer, podcast host, etc., who said some things about Ray Andiachero in relation to the death of Ray's child. Ray's child died. It was ruled to be a self-deletion by the government, but Ray believes that this might be incorrect and has brought, attention to this issue because she thinks that there's evidence that it might have been, in fact, murder or foul play. So that's, perhaps what's going on. Karen Yaks over here, for her part, wants to report on this. Okay. We report on things. But then Karen said some things about Ray that, for example, Karen said, among other things, that Ray got minors drunk and that she had clients of her own, because Ray is a mental health professional as well, that she had clients of her own that then self-deleted because of Ray's malfeasance as a provider. So, calling into question that she committed crimes by, giving alcohol to minors, bribed people to falsely testify, that she is a bad mental health professional to the point that her own clients have committed self-deletion and so forth and so on. So Karen said all kinds of crazy shit about Ray on the basis of not apparently very much. Karen, apparently not realizing the thing was serious, decided not to play along. She decided not to play, and she got a default judgment against her because she's like, I'm just not going to respond to this lawsuit. She tried to dick around and play games, and so we are on the far end of the equation of F around and find out. That's where we are. We are on the sort of ultimate culmination of F around, find out. F around and find out by making up lies, by making up statements that have no basis in fact, or at least that you aren't willing to provide receipts for, or haven't been able to provide receipts for because judgment against you. And now you owe $500,000. So it's not going great. So I thought we could read this sort of end of the road order from the court, the district court in this thing. So we'll see what this is all about. So this is Ray Andiachero versus Karen Yaks. Karen Yaks, also known as the Critical K, in an order. This matters before the court to determine the appropriate amount of damages on plaintiff Ray Andiachero's tort claims against Karen Yaks. And I always apologize to Ray. I mispronounce her name, and I mispronounce it differently every single time. I'm just really bad at this, but I'm sorry. The factual complaints set forth and need not be recited at length or taken as true for present purposes because default judgment, because that's what happens when you don't play. When you don't show up and you don't participate, the court is just going to be like, you lose. So you lose. So the short version of the facts are this. On her internet webcast, podcast, YouTube, whatever, Yaks accused Andiachero, who is a healthcare provider in her own right, of committing bribery and contributing to the untimely deaths of Ray's son and one of the patients. So yeah, with the bribery, with the beer and facilitating minors, and that you are so bad as a mental health provider that one of your own patients took their own life. Statements that go to reputation of your professional reputation, statements that go to criminality. These are kind of bad. These statements, false, defamatory, unprivileged, actionable, and highly offensive, meet the standards set forth in Mississippi law for defamation, specifically slander and false light invasion of privacy. Yeah, you can't make up things about people. You can't just say things. You can't just say things like this woman did these things with no evidence or no proof, or at least none that you're willing to provide, none that the court is aware of, none that I don't know if there's evidence of this or not. I don't know, but I do know that you didn't play very nice with the court, and the court lost patience, and you lose. You lose. Good day, sir, Willy Wonka style. So now you have defamation and false invasion of light of privacy. Yeah. Each statement was made with actual malice, that is, with knowledge that was false or with reckless disregard. Yeah. I mean, fair. So the court held evidentiary hearing on damages in May. Andi Achera, for her part, testified under oath about the harm that Yax's false statements caused her. She confirmed for jurisdictional purposes the relationships those statements had with the state of Mississippi. She then provided as a point of reference a decision by Judge Sampson awarding $75,000 to a victim of defamation. Yax did not appear at the hearing despite the court's express invitation, which is unfortunately not the first time that Yax has not shown up. She has not participated throughout this proceedings. She has been repeatedly not showing up and repeatedly not participating, refusing to take phone calls, refusing to show up for hearings, and just not participating, which, is not really an option. When there's a case going on against you, you can't just not participate and hope it goes away. That's not really a viable option. So she did participate somewhat. It's not like she completely didn't participate. She filed a motion to dismiss, which she filed on her own behalf, which was about as good as you would expect, claiming that there was jurisdictional problems and stuff. So it's not like she completely failed to participate. She did do some things, but for the most part, she didn't really play very well. She didn't play well with others. For the most part, she didn't show up or take the calls. Like when the court said, hey, you and the other attorney, because you're pro se, so you're your own attorney at this point, you guys have to talk and coordinate a schedule. She wouldn't do it. You guys have to talk and coordinate discovery. She wouldn't do it. You guys have to talk and, figure out things. And she wouldn't take the calls from Ray's attorney. She wouldn't respond to the emails from Ray's attorney. And the court at one point was like, you have to participate in this hearing. And she's just like, no, I'm not going to show up and stuff like that. So she showed up a little bit, but she mostly was whining about things and mostly I'm not going to respond to things because I can't be bothered. Yeah. So, yeah. Because this case is proceeding in diversity, because, two different states, the applicable substantive law is that of the forum state. State law is looking by decision of the state's highest court, which, exactly what you would expect, right? A federal court, when applying state law, has to apply state law. So what does it do? It looks to the highest law that's available. So it's going to look to the best law that's available to try to figure out what Mississippi wants. So let's just do what Mississippi wants. Okay. In Mississippi, compensation damages are such the damages will compensate the injured party for injury sustained and nothing more, such as will make simply good or replace the loss caused by the injury. So compensation are just, what did you lose? And give it back. Damages for emotional distress alleged in connection with intentional tort may be recovered even when the plaintiff has experienced no physical injury. Your loss can be emotional. Your loss can be things. It could be stuff. It could be physical harm. It could be emotional harm. What will compensate you for the loss? So emotional harm, sure. The standard considers whether defendant's behavior is malicious, intentional, willful, wanton, grossly careless, indifferent, or reckless. In those cases where mental or emotional stress is a foreseeable result of the conduct of the defendant, a court can assign damages for mental and emotional distress. Yeah, it's going great. Because Yak statements imputed the guilt or commission of some criminal offense involving moral turpitude, such as, you tried to bribe witnesses to not cooperate and stuff, and infamous punishment, and imputed a want of integrity or capacity, whether mental or pecuniary, in the conduct of the profession, trade, or business, they are actionable per se and need no special harm. Defamation per se goes to your professional reputation. The Speed Court, for example, knows that being called a thief can be actionable per se because a crime like thievery is a significant criminal act. It points to a different case in which a Mississippi juror awarded cash $5,000 for slander after a manager falsely accused her of stealing $1,000. To place those sums in conduct, the U.S. Bureau of Labor Statistics says that $5,000 of 1917 has the same buying power as $130,000 today. So just to adjust for inflation. In this case, Andia Chero testified about emotional distress that Yak statements cause. For a parent to be accused of contributing to their child's death is its own kind of pain. I would imagine that that would be quite distressing on a lot of levels. Having that broadcast to thousands of people amplifies the pain. Knowing that tens of thousands of people have watched Yak's false statements, Andia Chero says, makes you very paranoid. It makes you very uncomfortable in public. You don't know who's listening and who's believing what she's saying, or who knows what she's saying is crazy. And so you do become very isolated and you don't go out to eat. You don't go do things that you normally did because you don't know where everyone stands that's around you. That seems pretty reasonable, I would imagine. I've never been a parent. I've never been accused of, contributing to the death of my non-existent children. But I would imagine that that would pretty much screw you up in every possible way. And then being accused of being the person behind it or being responsible for it. It's like, you already probably have enough self-guilt anyway, I would imagine, if you're a parent of any substance. Even if you had literally nothing to do with it at all. I would imagine that most parents in this situation are wondering what they could have done differently, what they could have done, how they could have stopped it, right? Was I a bad parent? Like, even if they're not responsible, I would imagine that most parents, upon the death of their child, are wondering, did I fuck up? Because that seems like a normal thing. Like, am I responsible in some ways? And so now you have someone saying, yes, you're responsible. You're the bad person. I would imagine that for some people that will really screw them up. So that seems like the kind of thing that could be really detrimental to a person's mental health. So, when you're accusing a parent of contributing to the death of their own child, it doesn't take a lot for that to be mentally taxing. The court heard testimony about how Yaks profited from her false statements. Perhaps the worst part, Andia Chero says that Yaks offered to share Andia Chero's son autopsy photos with strangers on the internet, which caused perhaps some of the most upset just knowing that people know these pictures of where he's naked and cut open and all that. Okay, yeah, we will just take the note to push aside the issue here about that. The issue is the threat really to do it, right? As opposed to maybe doing it, because there is a difference, right? Like, I'm threatening to do this to you versus just doing it. So there is something to be said in the case of that we've been covering recently with Yav girl or whatever her name is, right? She just made the photos available. So, and the photos were public in their nature. So they were public and she just made them public. So, did she do something wrong in making those public? We've been talking about that on a legal level. We've been talking about that on a moral level. But here, this is a little bit different because she's making the threat, right? I'm threatening you that I'm going to expose this. It's like, I'm telling you I'm going to do it, right? So the knowledge of it becomes its own torture, right? So that provides a slightly different case on the thing we've been talking about. So, yeah. Andia Chero explained at length the effects that Yak's statement had on her life and her community. After the webcast, people filed complaint with Andia Chero with the Mississippi Board of Nursing, which opened an investigation and found nothing. So people believed it to the point that they filed complaints against her in her profession. People called her employer. They accused her of embezzlement via complaints with the Mississippi Secretary of State, which commenced its own investigation and found nothing. For a sense of how baseless the allegations were, listeners even accused Andia Chero of overprescribing opiates, a class of drugs that Andia Chero does not prescribe. So, yeah. So can we prove? So, yeah, apparently some people believed Karen Yaks and started taking actions based on the things they heard. They believed the lies and started doing things on the basis of the lies. So guess what? You're a little bit responsible for that, So, you can't just make up shit about people. And then people, it's like, I'm not responsible for what other people do. You are a little bit. Yeah. You're responsible for a little bit of this. The court finds Andia Chero's testimony compelling. The mental and emotional toll of Yaks' false statements have taken on Andia Chero was obvious at the hearing. Being accused of bribing a witness is one thing. Being accused of contributing your own child's death is another. Yaks' false statements cause real harm and warrant damages, which, is perfectly fair because the court is acting as a fact finder. And like, I can observe this woman because she was before my court. So let me tell you, she seems to be actually distressed. She seems to have actually suffered some real harm. This seems to have actually caused her problems because I can observe her because she's a witness in my case. So, you know, yeah. The above cite case on emotional damages in Mississippi reveals a range of damages granted in a range of situations. The court has also looked at a different decision in Mississippi, which reinstated a jury's verdict of $500,000 in compensation for severe emotional distress. The calculation of damages cannot be reduced to a mathematical formula, which, reasonable enough, because the issue is always how much have you been hurt? So how much other people have been hurt in some situations is at best informative, right? Because the issue is how much you've been hurt. So if someone else has been hurt to the tune of these numbers, that's at best informative of what might be true in some sort of comparable case. But it's not reducible to a simple formula. The plaintiffs, like defendants at criminal sentencing hearings, are individuals that must be treated as such. Fair, justice should be based on what the individual has done. For that matter, no sum of money can make a truly harmed person whole. Finders of fact are nevertheless obligated to determine a dollar amount to approximate that goal. And relevant cases illustrate ranges from which reasonable damages can be discerned. So yeah, we take a look at comparables, right? So if you want to know what the price of a house should be, one of the ways you determine what the price of a house should be is by looking at comparables, comps, right? What have other similar houses sold for in a comparable market, which is going to be informative, because every piece of property is legally unique. Every piece of property is by definition unique. So all these comparables are at best informative, but we have some information. So therefore, based on all this, the court believes the evidence supports an award damages between those identified in various cases and assesses compensation at $325,000. So, okay, fair enough, right? The court has been submitted with some care. Now, this is also a good reason why Karen probably should have participated in her own case. That would have been nice, because I don't know if there are other cases out there that are other comparables. Probably. There are probably other cases out there that could have been brought to bear and be like, these are other ranges or other ways of differentiating these cases, right? So like their attorneys, Karen's attorneys over here, or apologize, Ray's attorneys over here, rather, with like, here's some comparables. And like, where's Karen's attorney, which in this case is her, where's her with here are the other comparables? Or here's why those cases are not as comparable as they might appear. But when you don't play, you get whacked around for $325,000 in compensation. The next issue is punitives. The court has been mindful of case law indicating the Mississippi fact finders error when they're influenced by egregious, outrageous, and obviously intentional nature of conduct to award compensation damages that are penal in nature. Punitive damages, rather, are the means by which they may be punished for the egregious nature of the conduct. They may only be awarded when the plaintiff proves by clear and convincing evidence defendant acted with actual malice, gross negligence, which evinces a willful, wanton, or reckless care. They are the exception rather than the rule. So the court is noting a couple things, okay? Compensation damages are merely to compensate, not to punish, right? So the court is taking note here that you should and must be cautious to not award compensation damages that are really punitive in their nature, because that's not what compensation damages are for. Compensation damages are merely to compensate how much you've been harmed. If punitive damages are appropriate, then they should be awarded as punitives, but you shouldn't conflate the categories. That's what they're talking about, right? So don't award compensation damages that are in fact penal in their nature, which is to say punitive. Make sure to keep the categories separate. Punitive damages are for punishment. Compensation is for compensation. And then notes that this is a higher standard and only for the exception rather than the rule. So it's not something you should do every time. It's only in cases which meet this higher elevated standard. The egregious nature of Yax's false statements warrant punitive damages. Yax's outrageous accusation that Andia Chero contributed to her child's death likely means the definition of malice, but at minimum warrants punitive damages because it was made with reckless disregard, and the court sets punitive damages at $165,000. So, yeah. So $325,000 plus $165,000, you know, well, and then awards attorney's fees of $11,000, bringing us to $500,000. So $500,000. The last issues is the attorney's fees. Counsel seeks $11,000, which is calculated by taking his hourly rate and multiplying by the number of hours he expended. The court finds this sum justified by evidentiary predicate. For these reasons, $325,000, $165,000, $11,000, which is well, technically, let's see, that's 6, so that's 8. So that's technically $501,000. So, okay, $501,000. So, yeah. So that is that. So, yeah, this is largely a situation of Karen's own making. She participated a little bit in the process, but she didn't participate in significant parts of the process. As the court knows, she didn't participate in this. She got default judgment because she didn't participate. She wouldn't take calls from the other side's attorney, as we've seen in the record, right? Where the other side is taking note that, like, they won't take my calls. The court wants scheduling dates and they can't get scheduling dates done. And, you know, all that stuff. So $501,000. That's a lot of money. And this is largely Karen's own making. If she had participated in it, she might have been able to mitigate some of this. She might have been able to get out of some of this. There might be other cases that are citable. But Karen largely didn't participate. She participated in some of the stuff, but, you know, as the court notes here, not so much. And then just to show you that Karen is just maximum Karening, because of course she is, Karen filed a complaint against Ray's lawyer with the Mississippi bar. Because of course she did. Because of course she did. And the Mississippi bar has already decided that there's no case and dismissed the complaint. But Karen really wanted to maximum Karen this and complain to the manager. So she filed a bar complaint because of course she did. And the bar told her to go to hell. So, yeah. Yeah. So all that stuff. And I don't know if it's undue sympathy on my part. I mean, obviously I feel bad for Ray. And I totally get it, right? But this is like, we've talked about Ray, and we've talked about feeling bad for Ray and, you know, for the death of the child and all the rest. But there is a little piece of me that feels a little bad for Karen. Maybe I shouldn't, but I feel a little bad for her. I feel like she got in way, way over her head, and perhaps her own arrogance was her downfall. And, you know, she's just beginning to understand reality. And she's one of those people that maybe wasn't able to take the hint at an earlier point. I feel just a little bit bad that her own arrogance apparently, and I don't have to participate in the court process, seems to be a major factor in her own downfall. So, yeah. So I feel a little bit bad. But, you know, you can't just make up shit about people. You can't just say that, you know, that Ray is buying beer for people and buying beer for use and contributed to the death of her own patient and contributed to the death of her own son. You can't just make up shit. You know? So $501,000 is the number at the end of the page. So I figured I'd bring this news to you. And I don't know that she has $501,000. So that's going to be interesting, I assume, and trying to collect against that debt. So, yeah. Yeah, will they get it? I don't know. I seriously doubt Karen Yax has $500,000. So I don't know where they're going to get the money from. So, yeah. And this is all intentional torts, by the way. This is all intentional torts. So she can't even file bankruptcy. I suppose she can, it just won't be effective. The debt is non-dischargeable because it's an intentional tort. So she can't even get rid of it in bankruptcy. So she'll just have this debt like sitting on top of her forever. Yeah, so no bankruptcies. Can they put a lien on her property? Sure. I doubt her property's worth that, but yeah, they could put a lien on her property. She won't be able to sell it, I suppose, until the lien is satisfied. But yeah, you could get a lien against her property. You could get writs of attachment. You have to first of all get this registered in her home state, which is easy enough. Once you get the actual judgment, well, it'll take a little time. You take this and you have to get it registered in her home state, which is easy enough. Then you can get writs of attachment and you can start doing liens against her property and stuff like that. So, yeah. Can they garnish her wages? Yes, I believe they can. I think it's up to a fixed percentage. I forget exactly what the limit is. I want to say it's something like a third that you can garnish someone's wages, but it's been a while since I looked. They can also go into her house and take her stuff if she has anything of value, which somehow I doubt. But they can get writs of attachment to take her stuff if she has anything of value. Will the court amortize or trust regular payments? Oh, you're thinking about a bankruptcy court? Oh, well, that's way too far in the future. She can receive a garnishment? Oh, yeah, sure. Yeah. Yeah, you can garnish her wages. Yeah. Yeah. Garnish wages. That's just the technical name for it. When you put it's the technical name for when you basically put a lien on someone's wages. So basically, the employer just pays the person directly. It's called garnishment. So you get the right orders. You get the right orders, and you give it to the person's employer, and they just take 30% out of the check, and they just send it directly to you. It's called garnishment. So you can do that with like child support orders, and you can do that with judgments. And so it'll just be like a line item right on your check. Deduction for garnishment minus 30%. So yeah. She would have to have a job. That's true. I don't know if she has a job or not. Don't a lot of states heavily disfavor this garnishment? I don't know. I believe many states limit it. I don't know that any state disallows it. I can't speak to states disfavoring it. And different states have different rules on garnishment. So maybe her wages can't be garnished. I don't know. But it would be expectable. It'd be typical. YouTube could take a percentage out. Yeah, except she doesn't have a YouTube channel anymore, but they could. They could attach her bank accounts. That's true. If they can find her bank accounts, they can get attachments against that too. And they can suck the money right out of her bank account. Yeah, they can do that. Yeah, you get writs of attachment. You attach it to their bank account and be like, yoink, it's my bank account now. Minus, just take the money right out of their bank account. Yeah, you can do that too. So there's lots of options. Although most judgments don't get fulfilled. So most judgments don't get fulfilled. But we'll see. I feel a little bad for her. I feel like she got in way over her head and her own arrogance wouldn't allow her to back down. Maybe we'll try to have Ray on at some point. That'd be interesting. Maybe we'll try to have her on at some point and we can talk about this case and how it's impacted her. What's her state before? I want to say Michigan or Minnesota or something. I want to say it's one of the M states. Did she have an attorney? No, she went pro se. And it went about as well as you would expect. Yeah. We should see if we can get Ray on. Let me ask her attorney. Can we get an interview with Ray. Oh, here's her attorney wants on. Okay. How'd you like to hear from her attorney? Let's invite her attorney. Okay. We'll bring the attorney on. Hold on. Talk amongst yourselves. This is Ray's attorney, by the way, obviously. We're not having Karen Yax's attorney on, which is also Karen Yax. Maybe another time. Let's see. And we'll see what her attorney has to say. And he can probably try to teach me how Ray's name is actually pronounced. That'd be good. No, I have his contact information. I just sent him a text message. I got it. That's fine. So we'll give him a second to see if he can join us. Thank you for the $10, 10 super chats. So we'll give him a second to see if he can join or not. Send it to his email. Okay. He wants me to send it to his email now. La-di-da. Send it to his mobile number. Send it to my email. Okay, fine. Fine. Give him a hard time. Let's see. All right, so I need to go over here, need to go over here, need to go over here, need to go over here. Do this, copy this, compose this, do this, do this, do this, do this. And we'll have Matt on. Matt, the attorney. All right. Hopefully that'll work. We'll give it a shot. You sent me a super chat? All right, let's take a look at super chats. My mind is in too many places at once. Eliza says, I DM'd you on Twitter last week or so. What's the best way to get in touch with you in the future? Email, maybe. I might have just ignored your... What email did you send me from? I'm looking at my emails. I don't see anything that's from Eliza Clips. All right, hold on. I have to change my sound output things. Okay, do this, do this, do this. Great. Hello?
Well, hello there. How are you?
Okay, great. How are you?
I am doing well. I had a pretty good news just a little while ago, so we're very happy.
Yes. So congratulations, first of all, on the decision. It's very good for you and your client, and the judge seemed to have come up with a decision that at least makes some sense on the rationale. So looking at some comparables to try to find a number figure that looks good, and the judge, of course, noting that he had the opportunity to hear from Ray and how it impacted her. And I'm like, yeah, if my child died and someone accused me of being responsible, that probably screwed me up a little bit too.
Well, it was a very emotional hearing when we put Ray on the stand. I'll tell you what happened. We had the hearing on the day in question, and the judge actually took it during a break between a big criminal trial that was going on. And so while that break was going on, we had the hearing, and we put Ray on the stand, and she was just magnificent. She went into all of the particulars about how this has hurt her, of how this has affected her emotionally. She was very emotional on the stand. And the judge was very compassionate. He was very understanding. He was very, how do you put it? I've been around, I have been around several judges in my 17 years of practicing law. And this particular judge is probably one of the most thoughtful and considerate judges I've ever been around. And I'm not just saying that because he ruled in our favor. I just mean in the sense that, if you've ever been in court and you've been around judges that when they rule for you or rule against you, they put a lot of thought in it, and you can respect whatever the man says or whatever the woman says because you knew they put an awful lot of thought in it. Well, that's exactly how this judge works. And he was just a very, very thoughtful and compassionate in his rulings. And he gave my client a lot of grace and understanding when she was getting emotional on the stand, and it was just I couldn't ask for more, honestly.
Well, I'm glad to hear that, and I wanted to make sure that we got the facts on sort of how Karen did or did not participate, because she filed that motion to dismiss such as it was, and did she participate in the case beyond that?
The only participation she ever did in the case was emailing the magistrate whenever she didn't want to participate.
Yeah, I remember seeing that on the record, and it's like, have a scheduling conference. And it's like, she won't participate with you. It's like, this is ridiculous. You have to like we talk, and so we can get this thing moving along.
And the funniest thing first of all, the funniest thing in this whole case was when she decided to file a motion to dismiss claiming poverty, and she decided to put a stamp. Well, she mailed it from Hawaii when she was on vacation.
I've never been to Hawaii. I'd just like to note for the record. So she's got one up on me.
I've never been to Hawaii either. And I don't know if you do any real federal practice or not, but I know on PACER, it's unlike what I see in some state court proceedings, but in PACER, they will actually take the envelope from a pro se and put that as an attachment. So, if you're just a run-of-the-mill attorney who's using PACER or ECF to file electronically, you don't know where the person is when they're filing it or whatnot, but she used express mail to send this to Jackson, Mississippi, and I just happened to look at the envelope and I saw it said Honolulu, Hawaii, and I'm wondering, what the heck? So we decided we were going to have some fun with that.
Melakilikamaka is the way to say you're getting sued today?
Yes, it is. But her argument about personal jurisdiction was, by the way, you asked a minute ago, you said it's not Andrea Chero, it's Andrea Accio.
Andrea Accio.
It's like Andrea Accio.
Yeah. Andrea Accio. Yeah, I mispronounce it every single time, and I always feel bad.
But it's endearing how you do that. It's very endearing how you do that.
I'll take your word for it.
Well,
I know a lot of women really they consider it endearing when I mispronounce her name every time.
Well, Miss, Ray is one of the nicest clients I've got, one of the sweetest people I know, to be honest with you. Certainly you don't run her name in the ground, and she's not going to stand for that, and I'm not going to stand for it either. But short of that, she's very compassionate and very kind. But as far as the personal jurisdiction argument she had, it was frivolous in this regard. If she had just been sitting in her home state of Michigan talking about what's going on and had not made any contacts with the state of Mississippi, we wouldn't have filed suit in Mississippi. But when we saw that she had done one of these interviews and she was on the phone literally talking to Mississippi residents when she was running my client's name in the ground,
Yeah.
then I realized there you have minimum contacts under the Calder test and everything else you've got. And so you got your minimum contacts, and Mississippi and also practice in Tennessee. Both states have long arm jurisdiction statutes that pretty much equate to due process. I
Sure.
mean, if you
That's pretty
commit a
typical.
tort, yeah, if you just commit a tort in whole or in part in Mississippi, cause any damage here, then Mississippi will take jurisdiction over it under the long arm statute.
Yeah.
So
Yeah,
I thought,
I did wonder if there was maybe a slightly more clever version of the argument that Karen could have made, because I think, when we're talking about the personal jurisdiction issue, because we ran this issue with Toddy without a
yeah,
crystal ball with exactly this issue, right? Because like she never contacted anyone in the state, she never talked to anyone in the state, she didn't direct anything in the state, so the court is all about it. And and it's like, so if she had made like, because I said this in that analysis too, I was like, if she had made like a contact in the state, is it necessarily like a do or die thing, or is it just maybe one more thing? Maybe it's just another random journey along the way. So I wonder if there's some sort of clever argument to be had that, yeah, I contacted someone in Mississippi, but it's still incidental and not enough. But well, if
well,
there's an argument to be made there, it wasn't done.
I don't think there would have been in this case, because it's not
Yeah,
like she was just interviewing somebody in Mississippi. She literally committed the tort in question. For
yeah, that
example,
doesn't help.
yeah, she was talking to a couple of fellows when she said the statements about Ray, being this particular person's a medical provider, and causing, may have, implying that she'd had something to do with Christian's death and with this alleged patient's death. That was literally in a conversation she had with two Mississippi residents. So it's functionally no different than if I had gotten on the phone right now with you off of YouTube and just called you and I said, "Hey, in civil law, wait till you hear what this person did," and I make something up, and you know, and I call your home state, and I have subjected myself to the personal jurisdiction in your home state because I have committed libel or slander, I should say, slander in your state. So
Yeah. Yeah, I think on balance you're right, but it's just like I'll keep that one step of reservation out there for someday, because I think it's interesting. But yeah, so yeah, the accusations that were so over the top, and like they don't seem to be based on anything. It's like that's the thing. She alluded to the fact that she had receipts, but like she didn't really,
and we asked for the receipts in discovery. I mean,
as one would.
yes, and look, it's like this. Let's just speak in the abstract. Let's speak in the hypothetical. Let's assume for
Sure.
a moment, simply for the sake of argument, that that Ray is considered some sort of public figure. Okay, let's just say she is, hypothetically speaking, and then
Mhm.
let's say, hypothetically speaking, that Miss Yax, was relying on some evidence out there to back up what she was saying, and therefore she could claim that it was not with reckless disregard for the truth. Okay, let's just use those hypotheticals in play. I would have needed to see that information in discovery to determine whether or not I had a valid response to that.
Yeah, exactly.
And every time we asked for anything in discovery, except for, now, she did respond to some requests for admissions. She had sense enough to respond to those. But when it came to discovery and things along those lines, she immediately moved for protective orders, and that I thought were fairly frivolous. And, so you factor that into the equation, and it's like we would have needed that information to see the quality of the information you were using in order to make a determination of whether you acted in good faith or in reckless disregard for the truth. But she never did,
Yeah.
never gave us any of those, never responded in discovery. And so that is part of the reason why she was in the mess she's in. By the way, do you like the William Kunstler look? I'm sporting it right now. If only I had the little chain. You remember William Kunstler? I don't know if the
Yeah.
audience remembers him.
Yeah.
My glasses are dirty, so I can't read them right, use them right now. But at any rate,
Yeah.
so in that particular circumstance, she just didn't want to participate. She wanted to take her marbles and go home.
Yeah. No joke. And she shows such obstinance and arrogance, to just like not wanting to participate in any step of the way. And I feel like she had so many chances to like back out of this thing, and she just would not take any advantage. She just wanted to be stubborn headed and not participate, and just she wanted to she starts thumbing her nose in the court. I'm like, dude, that's not that's not going to end well. The court actually has power over you. You don't want to piss off the court, man.
Oh, I know. Oh, no. Now, it's a little bit of backstory. So we filed our complaint, served it on her. Then she did her motion to dismiss, which was a pro se motion. And look, I've heard pro se motions. I've read pro se motions. I mean,
It could have been worse.
it could have been worse. I mean, I've seen pretty bad lawyers' responses. Okay, so I mean, she hit the essential points. Okay, I knew what she was talking about. And then we had the whole argument about personal jurisdiction, which I've gone into, and the court ruled in our favor, but told her she could renew this motion later if she wanted to. Okay, so then we get to the Rule 16 conference, and the Rule 16 conference is a scheduling conference, but it's also a conference where we get to determine the boundaries of discovery, like how many interrogatories are you going to do? Just one second. How many requests for admissions you can do? How many depositions you can do? All of those various things. And typically, and for those of you who may not, in the audience who may not be aware of how this works, is that you usually meet with the magistrate. Some magistrates want to have it in person. Some will allow it over the phone. And the attorneys before the conference are supposed to work out a pretrial order and try to agree to as many things as they can about the parameters of how litigation is going to go. And then once that is done, then you have the order. You send it to the judge. And some districts, Mississippi does an awful lot of things called. Are you familiar with confidential memorandums in federal court? Have you ever heard of that before?
No.
Okay. Mississippi, in the local rules, we have a procedure where it's either sometimes it's at the beginning of the proceeding, and then later it's also before you get to do the final settlement conference. The magistrate judge, not the district judge, but the magistrate judge wants both parties to send an ex parte memorandum explaining their position honestly and openly, and the strengths and the weaknesses of their case, so that the magistrate then later can work in a mediation in a settlement conference and will be able to work out something. But it never goes to the district judge. Have you ever heard of anything like that before?
No, it's like, yeah, well, you want me to highlight the weaknesses of my own case. It's asking a lot for me.
Well, yeah, but we have some very good magistrates here in Mississippi, and they read that, and the lawyers are fairly straight up about it, from what I gather. At least I've always been. I've never read anybody else's. They're confidential, but at any rate, so we had to do that little settlement confidential memorandum, send that off to the judge, and we were supposed to have met each other and do an order of whatnot to give to the magistrate. But Karen just didn't want to participate. And it was almost as if she was afraid of being on the phone with me.
Yeah, that seemed to be a thing where she said she felt threatened just by being on the phone. It's like, you're like, I'm not that threatening a guy. I did like your response. It was cute.
I can be sarcastic if I need to be.
I appreciate that. As a man who dabbles in sarcasm, I appreciate that.
Oh, I'll have to text you later another case I did one time. The pleading was amazing, if I do say so. But anyway, I digress. So we had this thing scheduled, and she didn't show up for it over the phone. and the magistrate was very patient. She didn't get angry or anything like that. I mean, very, very, very patient judge she is. And we waited on the phone for a little bit, and she didn't come in. And she decided, all right, well, I'll just go ahead and enter my own little order and let you know about it. And we went on our merry way. And she entered the order and entered a fine for Karen. Told her to pay her $100 within a month, and she did that. Give her credit, she did do that. And then the discovery period began. And during
$100 sanction was a very nice sanction. For 100 for screwing with the court and not showing up, is like all I have to do is $100, man. Damn. Cause like, can I get a piece of that? Shit. That's nice.
I had a judge, you'll love this. I won't say what county, I won't even say what state, because I practice in 2 states. But I had a retired judge one time say, when he was still a judge, he always told new attorneys to come to court with 3 crisp $100 bills, because that was the bond for contempt of court, just in case you need it. But anyway, we had discovery, and so I proceeded to send out interrogatories and requests for production of documents. I wanted to see her, everything she had from YouTube, everything she had from anything she had gotten from anybody about this case, because I needed to see whether or not this was, if she had a basis for it. Okay. But not only that, I also remember now, she was alleging, or at least she was implying, that my client had something to do with the death of Christian Andracchio.
Yeah.
Okay? Well, truth is an affirmative defense. And she asserted truth as an affirmative defense. So that meant I needed to see if she had anything that that could go to that effect and prove that. But not only that, if there was that opened up the Pandora's box for anything that related to the death of Christian Andracchio, if you want to get right down to it. Because think of it this way: if we had enough evidence from this case to prove, that anyone hurt him, killed him, did it, or whatever he did, by reverse implication, that would mean that my client didn't do anything to harm her son. And so that made that very relevant to this case. And so we even did some depositions to that end. Invited her, noticed her to come. Of course, she didn't want to appear even by Zoom. I told you that we sent interrogatories and requests for production. We also sent requests for admissions, which she did respond to those in 30 days, because somebody must have told her that if you don't, you're going to be in trouble with requests for admissions. And then she never sent any discovery to us, or to the extent she did, it was not in a proper form that one could cognizantly understand. I think, in fairness, she had wanted to put it almost seemed like she had tried to put some questions that she wanted in her proposed scheduling order that wouldn't have been interrogatory as a request for production. And it was like, that's the closest thing that she ever did. But she never actually went through the actual process of propounding discovery to us. At least that I recall. And so came time for a settlement conference. And this settlement conference was going to be scheduled, I want to say sometime in August or September of last year. And Miss Yax objected to having to go to the settlement conference because she did not want to come to Mississippi. Now, this particular judge, the magistrate, is and I'm sure you've explained the difference between magistrates and district judges to your audience, but just in case somebody new is listening, the district judge is what we call an Article III judge, who is appointed by the president, has a lifetime appointment, and is basically the big judge. Is basically the judge who enters all the major judgments and all the major rulings. But a magistrate judge is a specially appointed judge that hears the discovery disputes and handles some of the pretrial type things to take loads off of the district judge. And sometimes the magistrate judge can hear cases and make recommendations that the district judge can sign off on or not. At any rate, so this particular magistrate judge was responsible for hearing the settlement conference and doing that. And it's been her experience, and I think it's very wise, is that sometimes you need to actually have people in the room to come to a settlement conference, because if they're sitting in the living room of their house and they're eating Cheetos or drinking a Coca-Cola while they're on the YouTube, and they don't have any skin in the game, they have not physically gotten off their butts, gotten in their car, or gotten in a plane, or gotten to wherever they need to go to a settlement conference, then they're not going to have enough skin in the game to make a committed effort to settle.
Yeah.
So the judge wanted her.
It is definitely different being in the room. I mean, I think video conferencing has proven that in every possible way from COVID. It is different being in the room. You cannot fully replicate being in the room.
You can't. So she had said that she set this for a particular date. I want to say it was in August or September originally, and Miss Yax objected to having to come, and the judge reiterated that, you know what, I said what I mean what I say. You're going to come, but I'm going to be fair to you, Miss Yax. I'm going to go ahead and reset this another month out until October, so that you'll have time to come to Mississippi for travel time.
Yep.
Okay.
Yep.
So now you have to understand, I live in the northeast part of Mississippi. Jackson is in the state capital. We filed in the southern district of Mississippi in Jackson because my client lives in Meridian, and that just happens to be the county where it falls. So when at the time I filed suit, I actually lived closer to Jackson than I do now, but now I'm about 3 hours away. So it was about a 3-hour drive down there. Had to, get a hotel room, stay all night, go to the hearing, stand there, wait about an hour. Nobody shows up. And
so what do you want to do with the rest of the day? You want to go see some sights or something?
Yeah. So we get there, and lo and behold, and now the time may be a little off because of time zones. I think Michigan is an hour ahead of Mississippi. But depending on how you look at it, there was evidence later presented that at the precise time the hearing was going on, or maybe an hour before it, Karen was tweeting out or messaging somebody saying, "Look, I ain't coming to Mississippi. I don't know what they're going to do, but I ain't coming no matter what." And it was very contumacious. Very. And so,
I remember that. Yeah.
So the judge didn't appreciate that. Now, again, let me explain something to you. Let me just tell you how patient the district judge and the magistrate judge are. Okay. The district judge is probably one of the most avuncular. I don't know if have you ever heard that word before in a long time? Avuncular, kind of like your uncle. Okay. Very, very polite, very warm, friendly. You know what I'm trying to say? Very patient, sure. Even keeled. There are some judges out there that they wear the robe and they want you to know every 5 minutes that they wear the robe. Okay.
Yeah.
This particular judge he knows he's the judge. He doesn't have to remind you. Okay. And he's very cordial, very nice, very patient. And his magistrate is too, honestly. And they were very patient. There was no we're going to get this woman. We're going to, no anger. But anyway, we after that hearing, we filed a motion for citation of contempt because of, obviously, she was in contumacious contempt because the judge literally told her to be in Mississippi, and she didn't have any valid excuse for it. In fact, she was flaunting her decision not to.
Yeah.
But then I got to thinking, would this be possible a ground for a default judgment? So I started, now we're in the Fifth Circuit, and the Fifth Circuit has a different view of Rule 55 in this regard, but there is than other districts. But in some circuits, under Rule 55, the proceeding that talks about the part that talks about, a defendant who fails to answer, respond to a pleading, or otherwise defend. In other circuits, that's interpreted to be, well, if you're just not going to play ball, we'll go ahead and default you. Okay.
Mm-hmm.
This circuit's a little bit more tougher than that. They view that on a more narrow interpretation, and they say the otherwise defend means you haven't filed a motion to dismiss or a Rule 12B motion, something along those lines. So I knew I couldn't do a Rule 55 on that. But what I could find was under the rule, and I want to say it's Rule 16, I'm citing from memory, there is a citation there that talks about how, if you don't participate in a settlement conference as ordered by the judge, then you can ask for sanctions, including things listed in another part of the rule book for like discovery violations. And one of the things listed was a default judgment. So, reason, if she's not going to play ball, we're going to ask for a default judgment. And as you know, the judge a few months ago ruled on that and set this for hearing. And of course, we go have our hearing, and the hearing was really interesting because we actually had audio visual of the clips from YouTube when she was talking, and including the clip where she referred to herself as a mother, you know what.
Mm-hmm.
Mm-hmm. And I apologized to the court before playing it. I says, Your Honor, I've never played anything like this in court where the F word is dropped. But and he says, I understand. So we played it. And I told you that when we had that hearing, it was literally in the middle of a trial.
Mm-hmm.
We'd done it during the lunch break of another trial. It was a big criminal trial. And by the time we were finishing our hearing, people were coming in the gallery getting ready for the next trial. And as I was walking out, you could see the expressions on some of the faces of the people in the audience who had no idea what this case was about. And when they heard what was going on, I mean, they're here for a drug trial, okay? They're here for a drug trafficking trial. And I'm just, and I walked out and I heard this one person say to me, good luck. I mean, it was just, they literally saw that there was something awful about what this woman had done to my client. And it was, it was just repugnant what she has done. And it was obvious to any objective observer who had never heard of anything like this before. So there you have it.
That's a pretty powerful moment, when people in the gallery are just getting aghast from all they're at. But yeah, I mean, it's not surprised that the court just eventually loses its patience, and that's going to happen sooner or later. Some judges, as you point out, are just real dicks, and they'll just be like, you breathe the wrong way, I'm going to start holding against you. But some are more patient, but eventually patience runs out, and it's like, you don't want to be that person. And it's like, what options do you really have at this point, because you didn't participate in the process on appeal. It's like, it's the errors such as they are almost by your own invitation at this point, because you're not even there.
No. You've got to show respect to the court. And look, I understand that there is an inconvenience about coming multiple states and going things. Heck, that's the reason we filed suit in Mississippi, because we didn't want to go to Michigan.
Good for your client, right? And it's like, and you have the basis for jurisdiction. It's like, the argument against is harder. And I think, it may very well be unwinnable, because I think your point is very well valid. So it's like, you have the basis to sue there, so why not? Yeah.
Mm-hmm. So with that said, it was like, okay, why should we spend time and effort and money to go sue somebody in their home state when they directed their comments to our state, causing my client harm in this state, and committed the tort in whole or in part, not just by damages being held here and being felt here. That's not enough. It's got to be her actions directed to the state of Mississippi. And when you consider the fact that she was interviewing people who were domiciled in Mississippi when she called them,
Yep.
And one of the things that we alleged happened while she was on the phone with those people.
While they're in
Then,
Mississippi, so that would seem to do it.
so I mean, you know,
Yep.
we didn't ask to be, we didn't ask to have, my client didn't ask to have her name run in the ground. Um, so you know, this was all on Miss Yax. Miss Yax didn't have to say anything at all. She could have kept her mouth shut. She could have gone and talked about someone else, something else, and this would have never happened. So I didn't see the need for my
Or just
client
stick,
to
or
go with
just
Mary
stick to the, or just stick to the facts. I mean, the facts themselves are interesting enough. You know, you have someone who's dead, and there's, you know, competing theories about why, and there's, you know, there's a story there to be had if you want a story to be had. So you don't have to make things up to make it interesting.
And not only that, I mean, look, or let's use something we all know about, okay? The Kennedy assassination, okay?
Yeah.
Everybody has theories about what happened on November 22nd, 1963, right? There are some people who believe that, you know, Oswald did it by himself. Some people think the CIA did it. Just go down the list, all right? You know, in that scenario, though, if you're going to have a discussion about something that you were not a witness to, because neither one of us, I suppose, were alive back then, right?
That was not.
You know, we might have opinions about which side is, which theory is accurate and which theory is not, and the reasons for it. But what you've got to do in those circumstances is present both sides of the case, present all of the things, and explain kind of why you like this, why you don't like this, and that's how you avoid a reckless disregard for the truth situation. You know what I mean? I
Yeah,
mean,
absolutely.
but when you claim that you are going to be impartial and that you're going to view things from a different angle, and then you actively advocate for a position, and then you cross the line by bad mouthing a crime victim,
Mm-hmm.
you know, on a personal note, a month ago today, my nephew died of cancer. He was 37 years old.
I'm very
Um,
sorry to hear that.
well, I mentioned that because I've seen my sister go through the loss of losing a son, and God bless her, she's taking it very well compared to what it could have been. But having recently gone through that in my own family, the thought of somebody going to my sister and blaming her for what happened, or accusing her of having to do, I mean, that would be outrageous, you know. And in fairness, Miss Yax never flat out said my client killed her son or my client caused this other person to die. But the thing about it is, in Mississippi, we have, in a case called McCullough versus Journal Publishing Group, there was a predicate in that case for creating a doctrine, although it's never really described this elsewhere, but of defamation by implication.
Sure.
Meaning,
Yeah.
so I can say facially true statements and arrange them in certain orders, and do that, create a message or communicate a message that makes an implication that is defamatory, and that's what we alleged in our complaint, and now that we've gotten a judgment, it's been adjudicated as a matter of law as having been.
Yeah. So what is next for your client, I suppose, in all this? I mean, she has the, I guess, twin recovery issues of dealing with the death of her child and also all this nightmare. So what is next for her and sort of that progression?
Well, in so much as this particular case is concerned, you know, once various time limits that are requisite in the rules and whatnot expire, and statutory time limits or whatnot, we will be in. I've already contacted a law firm up in Michigan to begin the enrollment process, and we'll see what we can do on that end. Now, what's interesting, because this is a federal judgment, of course, you know, we can also, and I'll have to check and see. I don't know anything about Michigan law. I'm not a Michigan attorney, but it's been my experience that in federal cases, you can sometimes take a federal judgment and enroll it in the federal district court there. But whether you need to go a step further and enroll that under Michigan law, I don't know. I mean, I will have to ask somebody about that. I think you probably would have to. But we're going to take it from there and see what we can do. The fact is, my client, we wanted to we didn't ask for this, but we knew this kind of this vitriol coming from somebody like her needed to be addressed, and here we are, and we've addressed it. So
yeah. And I'm also curious, what is the status of your client's investigation or lobbying efforts, or however you might want to phrase it, with respect to the death of her child? I assume that that's still ongoing as well.
Well, it is, but we have kind of a division of labor with the various lawyers that work with Ray, and
Oh, I
that
understand. If you don't know, then that's fine. I just figured
yeah,
I'd
I don't, I
ask.
don't, I don't have as much knowledge about those particular circumstances as others do. I do know that it, we have some other cases that are ongoing that I'm participating with. Probably not at liberty to discuss those right now. But aside from that, we're just excited today that we got a very favorable judgment. I mean, $500,000 in a judgment is nothing to
That's a
sneeze
lot of
at.
money. That's a lot of money. I do not have a $500,000, let me tell you. So that would more than bankrupt me. So I'm not imagining it's going to go well for her. So, and as I point out, because it's intentional torts, she can't even get rid of it in bankruptcy either. So
Nope. So she's going to have a bit of a problem with that, and
yeah.
I would think that if she tries to collaterally attack the judgment based on lack of personal jurisdiction, I think the finding of the court
Oh, she
in
won't.
this
She won't be
order.
able to collaterally attack it. Good. No, there's no chance.
Well, not only that, but think about it. The judge in his findings of fact even are referenced that our
Yeah.
hearing, because one of the things we did at the hearing was to articulate the evidence and present the evidence to show that this was a case of personal jurisdiction and minimum contacts. So I think
Yeah.
we've got our I's dotted and T's crossed, and we're thankful for a victory, thankful for a win, and hope that this is a lesson for. I mean, look, I'm a free speech kind of guy, and I understand that from time to time, even folks like you, folks like our mutual friend Nick Rakita, others, might slip up and say something from time to time that probably shouldn't be said, and I understand that. But at the same time, when you are malicious, when you want to bring pain and misery to someone else,
Mm.
or even if you don't actually want to, but you don't really give a crap about it, and then you go online and taunt that person and say that I'm a Powerball. You've never met a mother, what, like me, and
Yeah.
basically what says take me on. Okay, we will.
The Powerball's not looking really powerful today. It has to be said.
So we have never met anyone like her before. So there you have it.
Yeah. Well, better for you, I suppose, because people like her, unfortunately, are everywhere. So there's some people in this world, especially online, it seems to me, they're just like, no, she's just. I think she just got in way over her head in her own arrogance and her own sense of self-righteousness, wherever it emerges from, just won't let her see any sort of problem. She just can't admit to herself like the truth. She's not very good at taking accountability for herself. She's not very good at understanding things. I bet you she'll continue to feel like the victim and the martyr and all this, and ran about it for years and years and years. So,
Well, I
yeah,
mean, I'm sure she will. One thing I have figured out about this lady is she has absolutely no self awareness.
yeah,
Now, listen to me. Pride comes before a fall. There are things that, I've got friends that'll tell me, Matt, you're off base here. You're screwing up here. You're doing this there. I mean, nobody has perfect self awareness. Okay. Um, and, but this is just uncanny. Never seen anything
yeah.
like this in my life.
All right. Well, do you have anything else to say on this issue? If not, I'm going to wrap up the stream.
Hey, I got nothing else. Good to see you again, buddy.
Yeah, it's fun, and as you go to that Court of Appeals for the Fifth Circuit, give me a call. I can use the experience.
Take care, my friend.
All right, take care for now. Thanks for joining us. Bye-bye. All right, so that was Matt Wilson joining us from Ray's side of the fence. So that was a lot of fun. We really enjoyed that. I'm going to go ahead and wrap up the stream as well. I hope you enjoyed this stream. So, yeah, Karen, $500,000. So, not great. So, yeah, I don't know what went wrong here. It's just, I don't know. It's just like, I feel like some part of me just is like, you just got in way over your head, didn't you? And you just couldn't back down. You couldn't do it. And, hey, that's unfortunately what happens sometimes, I think. But, yeah, so that brings us to the end of the critical case. So that's all there is about that. I've been Uncivil Law. I hope until later, my friends, all is well. Cheers, my friends, and goodbye.